I referred to earlier, the judgment I referred to earlier regarding, it deals with an amendment that was sought at the very advanced stage of the proceedings, and then the judge, in his considerations, he dealt with issues relating to the pretrial order and the effect of a pretrial order, the binding effect of a pretrial order on the parties. So you can have a look. It's I don't know whether it's since been reported. It may be. I'll check, but I'll give you the citation on SAFLI. It's Scania Finance. Scania's SCANIA, Scania Finance, Southern Africa Pty Limited. Versus Aggressive Transport CC and another. Aggressive Transport CC. Don't know if I'll send something with Aggressive Transport, but the name is Aggressive Transport CC. And it's High Court case number I3499 of 2011. It's a judgment by Judge Smuts, and it was delivered on 22 January 2014. So you'll know from that the new rules came into operation in April 2014. So therefore here, the judge still refers to Rule 37. But you will recall that I referred to the old Rule 37 conference, which the parties had. It was a one-liner document that they filed. But then Rule 37 was amended to introduce this pretrial procedure before the new rules came into operation. So at this stage, Rule 37 had already been expanded to deal with pretrials. So the principles herein is tried and is still applicable. All right, so that's judicial case management and the process it follows. Simply because the parties had agreed to what is set out in the pretrial order. They've signed it and they filed it at court. So it's a document that's there and the parties are bound by what they've delivered. Of course, you can't rely on things like contempt of court, and something that's a court order obviously weighs heavier than something that's just an agreement between the parties. So to answer your question, yes and no. In certain instances, you would want this to be an order of court because you would want possibly to rely on contempt. It certainly has more substance if it's made an order of court. Let's consider what the rule says for the moment. If we look at Rule 26, the managing judge must immediately after and in any case within 15 days after the completion of the pretrial conference issue a pretrial order on Form 8 in such form as meets the circumstances of the case. So it really is open to the judge how he or she wants to proceed. If we have a look at Form 8, which you'll find towards the end of the rules, you'll see that the judge must, in Form 8, order the issues of fact to be resolved. So those must be made in order of court. It wasn't here. Now, what judges do in order to avoid having to retype everything is to say the pretrial order is made in order of court because that sets out these issues. So strictly speaking, in terms of the rules, it is required that it be made in order of court. And in this case, it wasn't, as you can see. So you follow why I say, strictly speaking, it should be, because that's the intention. But it doesn't mean that it's not there. It's there. The parties have agreed to it. The judge just didn't order it. So I, as a litigant, would insist that the judge makes that an order of court. And I do. When I appear in pretrial conferences, I say, my lord, can you please make the draft pretrial order an order of court? And if the order then doesn't reflect that, I'll go back and say it hasn't been made an order of court. You made the order in court. Can you please rectify the order? But absolutely. But of course, it opens the door for unnecessarily encountering hiccups when you have an opportunistic opponent who says, yeah, well, we may have agreed, but the court didn't make that an order, so I'm entitled to revisit that as I please. You see. So it just opens the door for unnecessary issues. The proper way to do it is to make it an order of court. It should be made an order of court. Then no one can wonder about it. The parties agreed and the court sanctioned it. This is now, it's cast in stone for the moment until the court orders otherwise. So if, for instance, the parties, let's say I want to revisit the list of witnesses I want to call, and there's no court order ordering those. The court never made that an order of court. Do I need leave from the court to change that? Probably not. I don't know. But why go to those issues if it's simple enough to just make it an order of court, as it should be in terms of the rules? Because Form 8 prescribes that that should actually be done. Of course, Form 8 says the judge must actually rewrite everything that's in the pretrial order in an order, which is unnecessary, because a more pragmatic approach would be to say, just make the pretrial order an order of court if the judge is so inclined. And or the parties should ask the judge, make an order, make that an order of court, and if it wasn't done, go back and say, you haven't done this yet, judge, please do this, because we need an order of court for the pretrial. So yes, I would never leave it to the judge to do that. As a litigant, I always seek such an order, and I make sure that the order is granted, because after all, it's my client's case. I want it to be properly done, and if there's some oversight, I can't say, well, the judge didn't see this, so what must I now do? The responsibility remains mine to make sure that it is in fact done. Okay, I'm not saying that judges can simply just not do things that they are required to do in terms of the rules. I'm just saying all parties have a responsibility, because the order is made by the judge in court. That is the order, not what is the written memorial or record of that order afterwards. We just need some proof that this order was granted, which is why court orders are written down and issued. But the order is what the judge says in court. Yes. So if the judge in court says the pretrial order is made an order of court, and it's not reflected on the written document, the party should go back to the judge and say, you made it an order of court during the proceedings, but it's not, so that is not a correct reflection of the order that you made. Because remember, the judge gives the order in court, in open court. Yes. And then it's written down in an order afterwards to have a written memorial or record of what transpired. That document is a draft pretrial order.
Is it draft?
It's a draft pretrial order that sets out the issues. The court must still issue and give an actual order.
Oh, okay.
It's not indicated on that paper.
All right, thank you.
It's indicated on the actual document. So what must follow is an actual order. So the court looks at this draft document that you've given, and that doesn't become the court order. There's a subsequent actual court order based on what the judge ordered in court. So the last slide for this session, which is actually just a continuation of what we did yesterday before we proceed to interlocutory matters for the remainder of the day, is sanctions. So it's important, and it's very important for you to read Rules 53, 54, 55, and 56. This really, and I'm not saying, please don't, or please proceed looking at those rules from this perspective. It's part 6 of the rules. The High Court has inherent jurisdiction. So in any possible permutation of sanctions having to be imposed, it's a guideline of what judges can and cannot do, but that's not to say that that's all a judge can do. Sanctions are listed here for failure to comply with the rules, with a practice direction, a court order, or a direction given by a judge. So it tends to guide a judge on what to do and not to do in such instances. So if any party or his or her legal practitioner, if represented, without reasonable explanation, fails to A, attend a case planning conference, case management conference, a status hearing, an additional case management conference, or a pretrial conference. B, participate in the creation of a case plan, a joint case management report, or a party's proposed pretrial order. C, comply with a case plan order, a case management order, a status hearing order, or the managing judge's pretrial order. Or D, participate in good faith in case planning, case management, or pretrial process. E, comply with a case plan order or any direction issued by the managing judge, or fails to comply with deadlines set by any order of court. The managing judge may enter any order that is just and fair in the matter, including any of the orders set out in Sub-Rule 2. So you see what I'm saying. It's a guideline. It's not a limitation. The managing judge can make any order that is just and fair in the circumstances. Now, what Sub-Rule 2 says what a judge can consider doing is 1, and this is without derogating from any power of the court under these rules, the court may issue an order to A, refusing to allow the non-compliant party to support or oppose any claims or defenses, striking out pleadings or part thereof, including any defense, exception, or special plea, dismissing a claim or entering a final judgment, directing the non-compliant party or his or her legal practitioner to pay the opposing party's cost caused by the non-compliance. Okay, now let's consider for a moment in practice. A party is called upon to attend a case management, the parties are called upon to attend case management conference. Case management conference is set down for, the parties are, case planning is done, pleadings have closed, and the parties are required to attend a case management conference. The court says, all right, parties, you are to attend a case management conference on 16 November. 16 November comes, the plaintiff is there, and the plaintiff has filed a one-sided case management report, and the plaintiff has filed an affidavit. The defendant is not there. Whether it's the look, I mean, if a party is represented, the defendant doesn't physically need to be there. The representative is there. And as I said, I may be instructed counsel in a matter, but my instructing counsel can stand in for me. I don't also have to be there, as long as a representative is there. A representative who is informed of the matter. So you can't send someone who's just received the file and doesn't know. He or she must be able to address the judge on issues relating to the matter. So it must be someone who's competently informed of the matter. So now this is what you're faced with. On the 16th of November, Mr. Plaintiff or his lawyer is there. They filed a one-sided case management report. And in the affidavit, they said, defendant ignored me. I sent 2 letters. They are attached. I've made telephone calls. I left messages. The defendant has simply not engaged me at all in respect of the drawing of a case management report. Moreover, the defendant didn't file its discovery, which it had to do by 10 October. So what do you do now? You are now the judge. This is now what's transpiring before you. What do you do? No, remember now, your case management conference date was set in court at the case plan conference where both parties were present. And then a court order was subsequently issued. I'm the plaintiff. I say, my lady, I act for the plaintiff. I have filed, or my instructing practitioner has filed a one-sided case management report. This matter is set down for case management today. It was previously set down in a case management case planning conference where both parties were present. The defendant is not present here today or represented here today. We have also filed an affidavit explaining that the attempts made by the plaintiff to make contact with the defendant's practitioner, who is still representing the defendant, and the defendant has not returned any of our calls or any of our pleas, so we were constrained to proceed in that fashion. I'm in the hands of the court. Those are my submissions. Okay, so what you'll see in the rules, and it's important, is that the rule says you can issue sanctions. So I may actually get up, I might be very eager to get judged and say, a judge or my lady, this is what happened, please strike their defense and give me default judgment. But that's not to say that you should be giving it then. Okay. Because what the rules say is that without a reasonable explanation, where a party does that without a reasonable explanation. So you now know that we now objectively can establish that there has been various non-compliances in this matter. But for all you know, the defendant's legal practitioner may have died in the meantime, to take an extreme example. Okay, so there may be various reasons why there's been non-compliance. What should happen then to give effect to justice is that an order is made calling for a sanctions hearing. So what you would do is you would say the defendant or his or her legal practitioner is given an opportunity to make. So you can't present evidence before a court by way of oral representations unless you take the oath and actually get up and want to. But I can hardly think that a judge will ask counsel who's robed before him or her to actually just take off their robe and go and stand in the witness box. That's not how it works. So you'd expect an affidavit, and that's why the practice is to give practitioners or to give parties or their legal representatives the opportunity to file an affidavit explaining the non-compliances. Okay, and that will be set in a date, let's say 5 December, so it's a future date, a reasonable time. 2 weeks, I suppose, is a reasonable time. And then, of course, you need to, on the 5th of December, make sure, if nothing is received, you need to make sure on the 5th of December that this order did actually go and find its way to the defendant or his legal practitioner, which is why the rules make provision for that to be sent by the deputy sheriff. And what I would do, because now remember, I'm going to say to you as plaintiff's counsel, I'm going to say, my lady, on 5th of December, I'm going to move for sanctions. So I'm going to be there, and I'm going to be sitting there like a vulture waiting to get my default judgment. So as a prudent litigant representative, I would say, as I've done, I will also make sure that this order is served on the defendant and or his legal practitioner by the deputy sheriff, so that we're all sure on the 5th of December that the defendant or his legal representative received this order. It depends on whether the defendant is acting in person or by virtue of a legal practitioner. Now let's say on the 5th of December a number of things can happen. One, that legal practitioner has since withdrawn. It's simply filed a notice of withdrawal of representation. Says, I'm no longer representing this party. That's all you have. No one is there. All you have is a notice that's been delivered by this legal practitioner saying, I'm withdrawing as legal practitioner of record. That's all you have. It won't be either or. It's either the defendant, if he or she appears personally, or it's the legal practitioner, if it's represented. Remember, a litigant chooses, by his own accord, legal representation. Okay, so a litigant is bound by what his or her legal representative does. You can't say, well, I mean, I didn't know they were going to do that, so shouldn't be bound by that. Your legal you say to court, this legal representative can act on my behalf. And therefore the court will call on the legal representative to make the representations. Now the legal representative has just gone and withdrawn. In this scenario, I would say probably prudent to make sure that the defendant is also aware of what's happening. Does the defendant know that his legal practitioner has withdrawn? Does the defendant know that his legal representative was required to make representations? Does the defendant know that we're in court today? So you'd probably, if you want to avoid a short-lived order that's for which rescission is applied, probably cross all your T's and dot all your I's by saying, all right, this has now happened. I want to give a cost order de bona because he or she was called upon to make representations. You can't simply go and file a notice to withdraw. You have an obligation under court order to file a representation saying what's happened. But it now may very well be that you are innocent in this whole issue. So all you've done is you've just ignored my court order here. So you are in contempt, and I'm going to give a de bonis order against the legal practitioner. But that's now an issue aside. The other issue remains, can you now in these circumstances give an order that's going to be detrimental to the defendant given now a further non-compliance by his or her legal practitioner? Probably not. In the interest of justice, you should probably avoid because if you made an order, you've made an order. Then there must be an application for rescission, etc. So before you make the order, probably establish what the situation is regarding the defendant. We're not assuming anything. We're just not sure that the defendant knows. If this doesn't happen, the legal practitioner doesn't withdraw, you never need to mind yourself with whether or not the defendant actually, whether this person has told the defendant that there's this happening, because he's represented. So you can accept that once the lawyer is informed, the defendant is informed. Okay, but now there was a withdrawal, so you have to just first make sure what the position is regarding the defendant. Okay, let's say on the hearing of the sanctions, nothing happens. It's just the plaintiff who's there. You get nothing. Believe it or not, this also happens. You get nothing. So I'm there, I say, my lord, strike his defense, I want default judgment. And will you grant that order? There's nothing, no withdrawal, nothing. There's nothing before. There's proof that the order was served, and there's nothing more. On the legal practitioner. It's a represented or a defendant himself, whichever one is applicable, that's been served on them. Would you grant the order that I seek on 5 December in this scenario? In such an instance where you know that the order came to the knowledge of either the defendant or were represented to the legal practitioner, and on the 5th of December there were sanction hearings, or for the sanctions hearing, nothing has been forthcoming, the court should make the order it's entitled to make, because, of course, not only has there been non-compliance, that party has chosen not to make any representations or to file an affidavit in order to address this. So in my view, on this day, if nothing happens, make the order. Make the order. No court and no clerk of a judge is required to call parties to say, oh, did you know that you were required to be in court? Are you coming? Should we wait for you? Once the court has made an order imposing sanctions, the court is functus. If you want to set aside that order, you need to apply for that order to be rescinded. Absolutely. That's why I said where there's been a withdrawal of a legal practitioner, although you are entitled to assume that the order was served on a legal practitioner prior to withdrawal, that the defendant is aware of it, I would be wary to proceed against the defendant unless you know what his or her situation is. So yes, of course a court can order a legal practitioner to come to court. Look, I mean, your sanctions hearing was, you called upon a party to make, you gave them the opportunity. If they didn't want to use it, sanctions will follow. You can order a legal practitioner, despite the withdrawal, to appear in court. That's happened. I've seen colleagues being called to court by a judge, saying, you will appear before me tomorrow at 10. I want to hear you on what has happened here and why you have withdrawn. So that can also happen, of course. But yes, where a legal practitioner has withdrawn and nothing further has happened, I would first want to establish what the position is regarding the defendant before I simply make or impose sanctions. Well, your hands are not tied. You can say, I'm not postponing this matter. You can go get yourself another lawyer, but I've given you a number of opportunities. So we're proceeding with this trial with or without your lawyer. So that you can do, depending on the circumstances. But a judge can never force a party to be represented by a specific practitioner, ever. That remains the party's own choice. But what the judge can disallow is to be led by the nose in delays and postponements by a party who jumps from one lawyer to the other. So the judge can say, after the first or second postponement for change of representation, say, this is the last time. I'm not going to postpone this matter any further. You've had your chance. I'm proceeding with or without your lawyer.
Okay, so
But that'll depend on the circumstances.
okay.
As long as a party is given a fair opportunity to bring representation of his or her choice. Sometimes judges postpone matters in order for a party to get representation. It's postponed for 2 months, or the trial is postponed for 2 or 3 months. Then comes the day on the trial, and the other party says, I haven't found a lawyer yet. That's too bad for you, I'm proceeding. It's frustrating, but remember, the rules of the High Court make provision that a party may not withdraw. I don't remember the exact time period. I think it's 30 or 60 days. I'll check during the break. Before the trial, due to financial reasons.
Okay.
So you need to get your finances in order well in advance of the trial. It's exactly to avoid that circumstance. So if you are lax in securing the requisite deposit from your client in advance, then you are penalized by the court saying then you will proceed with this matter. You're not allowed to withdraw. No, and the court's approach in the High Court in civil litigation towards lay litigants acting for themselves is simply, I'm not going to excuse you because you're a lay litigant. You need to acquaint yourself with the rules. You need to know the forum that you're operating in. I'm not going to be bending over backwards to assist you, and I'm not going to assist you. You need to shape up or ship out. So lay litigants are not allowed leeway other than lawyers. Of course, when it comes to heads of argument and things like that, the court is going to be more lenient in the sense that a lay litigant is either not required, or heads of argument, or when there's less than perfect pleadings and there are technical issues, the court will probably be less stringent because it's a lay litigant. Although, strictly speaking, if you want to proceed on your own without representation, then you should know the forum that you're operating in and know the rules that are applicable. Okay, so let's say shortly before the tea break, what did I do with my blue? So let's say, okay, we have a very good legal practitioner, and he now files an affidavit. He's now there on the 5th of December, and he says, I was overworked. I had so much work that I overlooked this matter. I was very busy. I was very, very, very busy. And so I just overlooked this matter. Just being very honest. Saying I was overworked and I overlooked this matter. What do you think? Think it's a reasonable explanation? So what are we doing if we're saying to lawyers, okay, shame, you're busy. No problem, next time. I can tell you, I don't think there's anyone in this practice of the law that's not inundated with work. We all are. You need to learn to operate. So in my view, that would probably in the circumstances not be a reasonable explanation. So what you would expect is you would expect a reasonable explanation explaining exactly what was done and what wasn't done. So a full and frank explanation. Let's say the lawyer says, you know what, my father died and I had to travel to the north to attend to the funeral. I left this matter in the hands of an associate who didn't attend to it properly, and upon my return I received this order that I had to be back on be here on the 5th of December. Would that be a reasonable explanation in the circumstances? Probably would. And you can also be guided by, well, I mean, over time you'll know certain litigants have a sort of a pragmatic approach to opposing these types of things so if I was the opponent and this had been the explanation, I would say, want to argue this? I want my sanctions. You haven't reasonably explained the delay. Here I'd say, my lord or my lady, I'm not proceeding in assisting in sanctions. Can it be condoned, and can we please proceed and issue a new case management order? So it depends on the circumstances. So you see how these things permeate and how it depends on the circumstances. But be mindful of the fact that when you are imposing sanctions in terms of Rule 53, that you should do so where you are certain that the party against whom you are making this is actually aware of the responsibility that he or she had, and that you had given the opportunity to make representations. And remember, not evidence from the bar. The lawyer can't pitch up their robe in hand and just to throw it on and say, I was so busy. And there must be something on affidavit. You have to have evidence before you to consider. Okay, I think we can break at this point, and I'll deal quickly with the other 3 rules after the tea break. Any questions before we leave on this? Good. See you after the tea break then.